A last will is the most commonly used document for a person to transfer assets upon the person's death. The person creating the will is called the testator or grantor, and the person receiving under the will is called the beneficiary. States may have different requirements for a will to be valid, but generally, a will is valid if the will is executed by a person with the required or testamentary capacity, in writing, signed by 2 witnesses in the presence of the testator or at the testator's direction. What is testamentary capacity? A testator is deemed competent if he or she is at least 18 years old and of sound mind. Competency is measured at the time that the testator signs the will. Subsequent incompetence cannot invalidate a will. Usually, the soundness of mind is present when the testator understands or has the ability to know the nature of the property to be transferred under the will, the nature of the persons who will receive under the will, and the plan of the attempted disposition. Revocation of a will. A will can be partly or fully revoked. There are 3 ways to revoke a will: by the execution of a subsequent will, by physical act, by operation of law. Revocation by subsequent instrument. A later document can revoke a prior will. This is usually done by express language in the subsequent will. Example, Will 1 is hereby revoked by Will 2, the current operative document. Revocation by physical act. A testator also has the option to revoke a will by engaging in a physical act that destroys the will, such as burning, tearing, or crossing out the will. Operation of law. In almost every state, a divorce will revoke every provision in the will that is in favor of or benefiting the former spouse.